You can go on the internet and do searches about anyone. There are even companies devoted to helping you do these people searches. Spokeo is one of those websites. It gathers information about individuals from other websites, marketing tools, and social media. Thomas Robbins did a search of himself on Spokeo, and he found that the information was inaccurate. It overstated his education, his wealth, and his age. And it said he was married when he was actually single. So Robbins sued Spokeo under the Fair Credit Reporting Act. The Fair Credit Reporting Act requires consumer reporting agencies to follow various procedures when providing information about consumers. These procedures include providing notice to providers and users about the consumer, and following reasonable procedures to maximize the accuracy of the information. If an agency willfully violates these procedures when providing an information about consumer, that consumer may bring a cause of action for either actual damages or statutory damages up to $1,000 per violation. The Fair Credit Reporting Act defines a consumer reporting agency as any person who regularly assembles or evaluates information about a consumer with the purpose of disseminating that information to other parties. Spokeo does not consider itself to be a consumer reporting agency. It says it's just gathered information from other websites. The Article 3 issue in this case is whether Robbins has standing. Federal courts can't resolve all disputes. Under Article 3 of the Constitution, they can resolve only cases and controversies. And standing is one of the doctrines that makes sure that you have a case or controversy. For a plaintiff to have standing, he must show, among other things, that he suffered a concrete, particularized injury to a legally cognizable interest. And the precise issue in this case is whether Robbins has alleged such an injury. The Supreme Court agreed to hear this case to clear up confusion between two lines of Supreme Court cases. One line suggests that the violation of a statutory right alone might be enough for standing. The other suggests that you need some sort of factual harm beyond the violation of a right. There is some dispute about the harm that Robbins suffered from the inaccuracies in the data. He claims that he suffered reputational harms, emotional harms, and that it's made it more difficult for him to be able to get a job. But it's important to note that the standing issue in this case focuses on whether the statutory violation alone suffices for standing. Spokeo doesn't stand to gain much in this case, but it stands to lose a lot if it loses the case. Because if the Supreme Court holds that the violation of rights under the Fair Credit Reporting Act alone supports standing, Mr. Robbins, as well as potentially millions of other consumers, can stand to gain statutory damages up to $1,000 per violation. That translates into lots of liability for Spokeo. More generally, beyond the facts of this case, if the Supreme Court holds that a statutory violation can support standing, then standing is going to be broadened for many other federal statutes.